Well, hello again. My name is Steve Pletz. Welcome to the Contingent on You Listening podcast, here with my co-host, Isaiah Hernandez.
What's going on, everyone?
Contingent on You Listening podcast is a podcast sponsored by Century 21 Affiliated. We talk all things real estate. And I'm not going to even do some crazy big intro today because I'm so excited for the guests that we have in studio today. And as property owners, everybody always, I feel like as agents, we're always telling clients, real estate is a good investment. It's a good investment long-term. Values are going up, et cetera, et cetera. But then we kind of jump into a little bit of the discussion about rental property and just, hey, you can collect rent every month and it pays for your PITI, covers your mortgage, blah, 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 blah.
And we don't want to dive too much because fourth time's a charm. I mean, we tried this intro like 4 times.
We have definitely struggled to do this one, but we're excited that the team is looking at me with... we're
losing our guests as we speak.
So today, guests, Eric Ransavage and Nichole Dominguez of Ransavage and Dominguez Attorneys at Law. They are unlawful detainer attorneys. Super excited to have you guys in. We're going to just dive right in. And so what I thought we could start with is just kind of a general landscape of landlord-tenant relationships. I know that there's been, in the last few years here, there's been all kinds of change because this Tenant Protection Act, the TPA, was actually pre-COVID, right?
Barely,
like right before COVID. So give us a little bit of the landscape in the last couple of years in terms of like what has it looked like? How does this Tenant Protection Act take into consideration, et cetera, et cetera? Look at you guys.
Well, thanks for having us. I'm going to start, and then when it gets to the details, Nichole is much better at that than me. Yeah, the Tenant Protection Act, I believe, passed in 2018. It's a California state law. And it controls landlord-tenant relationships in the entire state of California. So that makes it different than many other states. Most states they've got local laws or they might have state laws. But this law specifically controls, it's a rent control law. So properties that are covered under this law, you can't raise rent a certain amount every year. And it's also a law that controls how you can end a tenancy. So again, if you've got a tenant back in the day before this law, if you had a tenant that was on a month-to-month lease, you could give that tenant notice and end the tenancy. You're done with that tenant. Okay, tenant, it's time to go. After this law, you cannot do that. This law controls under certain circumstances if you can end that tenancy or not. Basically, it's a function of our government giving tenants more protections, not having more homeless people in California. So those are the two parts of the law. Again, now the important thing to remember about the law, and this is what makes it complicated, is there's a whole lot of exceptions. So one exception would be a single family home is not covered under the law. However, there's an exception to that. If you're renting a single family home to a family, you have to let them know that it's exempt from the tenant protection law. If you don't, it's not exempt, which means you can't.
This is what's so crazy, and pardon me for interrupting, but I think that for such a long time, I feel like landlords have felt like they've been able to do this themselves. And by this, I mean rent out property, draw up lease agreements, like just figure it out. And it feels like to me, as a homeowner, as an owner of rental property as well, that it's gotten to a stage where even I feel uncomfortable. And I guess my first question is to you, as unlawful detainer, as landlord-tenant attorneys, how early should people get you involved? If I'm buying a rental property, should I speak with you guys before I even list it? And kind of as a landlord, what are things that I can do to protect myself?
Yeah. So this is kind of what I've referenced when you and I spoke before about being eviction minded.
Right.
Not necessarily that's where you're going to end up, but having an eye towards the worst case scenario might be able to help you avoid that situation altogether. So a lot of times people call us and it's never too late per se, but there could be a lot of wasted time. And from the real estate perspective, I have escrow's closing in 10 days and I have tenants in there. We're not going to be able to help you in time. And it's not that you can't do things, it's just your calendars aren't going to align. So I would say when you're thinking about taking on tenants, because there's some language that has to be in the lease, or else you're not going to get the benefits of being excluded from the Tenant Protection Act. Another caveat to that, which is a very practical thing, maybe you're an East Coast family who wants to come out here for the summers, but you rent out, depending on how long the tenants have been there, and assuming it's a single family home or a condo or something of that nature, separately alienable. Even if you want to move into it yourself, you're supposed to have language in the lease that says, basically reserving that right. So there's steps you have to take to make sure you stay in it, to make things easier for you if you get to that point where you're just kind of like, I want to be done with this. Because if you do, you're kind of operating under the rules pre-Tenant Protection Act, pre-COVID complications. But if you don't, you're going to find yourself being treated just like an owner who owns 50 apartment units.
I gotcha. Yeah, and kind of seen by the state standpoint as someone that that doesn't have a lot of these exemptions in place. How did COVID change your worlds in business?
Well, for 2 years, Eric and I, we went for runs.
We did a lot of running,
like personal
surfing.
Business. Yeah.
We ate a lot of lunches.
But from the court perspective and the practice of what we do, it's still affecting us. That's part of the issue here. We can talk about this in two parts: the things you can do to plan, but if things go awry, you are now in line for court, and court is still feeling the after effects of COVID.
Yeah.
There's such a backlog of cases that we've added. What used to be kind of a 1 to 2 month process is now easily a 4 to 6 month process.
And by process, you mean the eviction
The
process.
eviction.
Wow. Yes.
When you file your paperwork, yeah.
I felt like especially because of COVID, we talked about this off air, but I'm going to use the term squatters, and you guys told me that's not the correct term to use. That was a lot in the headlines from like post-COVID during that 2-year period and stuff. Can we just talk really quick about what these squatters are and like how that refers to like California and like the tenants and stuff like that? You know what I mean? Because you said that they are actually tenants.
Yeah,
considered.
so it's kind of just the common vernacular, you know, if we're sitting here having a conversation, anyone's going to resonate with the term squatter. The issue becomes when you try to get the law involved, as Eric said, there's no real legal difference between someone who wandered onto your property in the dead of night or someone who might be staying past their lease or after not paying rent. Once you hit the point where you need law enforcement to help you, the law is just going to treat them like a tenant. So Eric, maybe he can, re-explain this. There's kind of trespassers and people who are on the property with permission. But when you call a cop or a police officer or local sheriff and say this person they're here without my permission, they need to go, 9 times out of 10, that officer is going to tell you go get an eviction.
Wow.
Yeah, and I think it came up during COVID because what happened was, of course, all the courts shut down, all of the counties, cities, and the federal government had a moratorium on evictions. So if you had someone that wasn't paying rent for 2 years, you could not evict them. There was a moratorium on evictions. And so when you have a landlord that's been sitting there and someone's been living in their house for 2 years not paying rent, to that landlord, they'll use the word squatter. This person is now a squatter. They're not paying rent. But as Nichole had mentioned, that's not a legal term. If somebody's been there because they were there with permission earlier on, the term squatter doesn't mean anything. To the sheriff, when you call the sheriff, it's either going to be person's a trespasser, and they just ask, "Are you here like on your own?" And someone will say, "Nope, I live here. It's COVID. I don't have any money. I lost my job, so I'm just living here." At that point, the sheriff says, "You got to go hire attorneys to go get a court order to evict somebody." And that was what happened with COVID. And that's why it was in the news, because for a year or two, you had tenants that weren't paying rent and just situations like that. And then things really got out of control because people are getting restraining orders at each other. They're threatening each other.
And there was frankly, there was nothing a landlord could do, right, at that time. And let me, I realized at the beginning, I was supposed to give you a disclaimer that even though you're attorneys, that this isn't legal advice. So for those of you that have made it this far, we're 10 minutes in. If you've made it this far, this is not legal advice.
We'll put it in the description too.
We'll
So check the description, please.
We're not being paid enough money for this to be legal advice. You'll have to call us separately.
So I guess my question is, what can a landlord do to protect? Is there anything that a landlord can do to be prepared up front? Because I know that at least with our clients that they have money to invest. They like residential real estate, especially. I mean, throughout the country is appealing. People always need places to live. It's different than a retail space. Is there anything that a landlord can do up front to protect themselves?
Well, I think you kind of hit on this earlier. Investment property, residential especially, is kind of becoming a boutique set of skills.
Class, yeah.
And hiring a property manager, I think, is a good first start because they're going to do all the things that kind of go along with vetting potential tenants on the front end. But then in terms of the paperwork and the lease agreements and the addendums and all that kind of stuff, it's just their everyday skill set. Whereas we still see leases that come in and they're like one page printed from the internet that was put on there in like 1994 or something.
Do you work with the property manager specifically, or would you work with the homeowner?
So we typically get calls from the property manager when
Okay.
things start to go south, and they'll be like the intermediary between the homeowner. And it just depends on that relationship in and of itself. Sometimes a homeowner is completely hands off with the property, and so it's really the property manager who's, giving us all the background and all that. Or sometimes they're slightly more involved and they want to talk to us and just make sure, that the information they're getting is.
That's valuable to know. So that means that if I have enough money that I'm able to purchase property and have a property manager basically manage the whole thing and just say, look, I want this to be mailbox money.
Yeah.
I don't even I don't care who's in it. I just want to see money hit my account every month. Depending on the level of service with that property manager, it might be a circumstance where then when they need to get evicted, I'm not even involved as the homeowner. I mean, certainly my bottom line is involved. The money that I'm receiving or the money that I need to pay out is involved. But you're saying that you don't necessarily have to rope the homeowner into the legal proceedings?
Correct. Not every time. It depends sometimes on the ownership structure. Maybe their signature might be needed on something, but a lot of times the property manager can sign on their behalf too. Nice. So
I will say, the laws have changed. The law changed in 2019. Then COVID hit and shut the courts down. Even as lawyers, there's gray areas of the law that I don't know how a judge might rule on something. So there are property managers that we deal with all day long that are smart, capable people that still don't know a lot of these laws that have changed and maybe are using a lease from 5 years ago and are like, oh, wow, I need to use a newer lease that has this new language in it. So the only thing I'd add to what Nichole said, here in California, there are California Association of Realtors that create the leases.
Right.
You pay money for those. There are lawyers that help draft those. That's what you really want to do, even if you're a homeowner or a property manager, to use one of those leases, because the clients that are in the most trouble are ma and pa that come in that have been using the same lease for 20 years. Right. And then I look at it and I go, this is a single family home, but you're not going to be able to evict these people, or you're not going to be able to end their tenancy unless you, for example, need to demolish the house or something drastic like that. And they go, really? These laws have changed. So definitely a property manager helps, and those newer form leases help in California.
And because I feel like even as a realtor, I wouldn't say our broker does a nice job of keeping us in the loop of updated forms and those types of things. But as an everyday homeowner, it feels like in the last 2 or 3 years, things have changed so much, and there's no way to keep up unless I bring unlawful detainers attorneys in, unless I have a property manager that's up to date, that is doing this full time. And I think a lot of homeowners have a tendency to look at it and go, well, these people are cutting into my profits.
Yeah, an ounce of prevention, I think.
Yes.
And this ties into everything, like you brought up COVID. I was in court last week because a tenant had filed a declaration of COVID hardship. This is a wholly inapplicable form 99% of the time now. But it just shows you the fallout. This form was created for COVID. It has not yet been removed. Tenants can file it, which means the court on their own is going to schedule a hearing. I have to go into it just for the judge to say, hey, this form is inapplicable. And these are the kinds of things that are making these cases take longer. It's more paperwork. It's more filing fees. It's more court time. And then, like Eric said, the part of the Tenant Protection Act, the rent cap provision went into effect mid-2019 with the full effect, the eviction, which we can get into because it breaks down into cause and no fault, just cause, and just cause eviction. But that took effect in January 2020, and then March we had COVID. So basically, the brakes were pumped on the TPA, the Tenant Protection Act. It was kind of back burner, and all these COVID rules started coming out. And even the judge, we'd show up to court, and tenants would be, representing themselves and realistically very confused. But the judge would say, I'm confused. The lawyers are confused. These forms are coming out faster than
There's so much gray area. And that's what makes your life so difficult.
Yeah. And so now, even 3 years later, we're still dealing with terms like intent to withdraw from the rental market. Do I have to have that intent for the weekend? Do I have to have it for 6 months? And a judge tells us that. But we had to get through all this COVID stuff before we're even talking about that. And we're just still not really through it. So Eric and I always talk about best practices. We're either in court or watching court every day. And really seeing what the judges do is like the best finger on the pulse you can have. Because when you're just reading the language, it's vague, it changes slowly, it becomes outdated. It isn't what happens when it's put into practice.
One thing I'd add to that is, we've got the state law, but if you're an investor, real estate agent, we're dealing with a patchwork of laws as well. The city of San Diego has separate laws that were in effect for evictions, and Chula Vista now has a tenant protection, its own ordinance. So if you're looking to buy property in Chula Vista or the city of San Diego, it is something to look at. Vista.
So you're saying city to city is not just state to state.
Yeah.
City to
County.
city is county. Yeah. I mean, this is the thing. This is
It's
why
blowing your mind.
it is blowing my mind, because I think that for such a long time, I started in 2005, there was this feeling like, hey, Mr. Buyer, all you got to do is you got to get a chip on the table. You got to buy a small little condo, buy it for yourself. Then when you move out, keep it as a rental behind you. It's going to be smooth. It's going to be easy. You're going to be in at a lower interest rate. Rents are only going up. You can just do a handshake agreement and everything's fine. And that's not the case by a long shot. And or just the possibility of getting burned. It feels like it has increased.
Yes.
Yeah, the temperature's hotter.
The temperature is hotter.
But, and to that, I don't know, I think you might have been telling me before about, you put a rental up and you'll have 50 applications in 10 minutes. And Southern California is still a place where you can command fairly high rent.
Absolutely.
So I tend to think the pendulum is a little out of balance for a number of reasons. Court delays.
When you say pendulum, you mean like who it favors, favoring the tenant over the landlord? Is that what you mean?
Yeah, I hate to come down on one definitively,
right?
Because
you're an attorney.
Because there may be a judge that watches this or listens to it.
Eric and I are always like, it's very hard. This is someone's home; they own it, and to just kind of be sidelined is very frustrating. But tends to be the case that at some point they will get their keys back. It's just how it's getting drawn out.
Yes.
And those delays seemingly kind of just favor. I haven't seen a landlord who's benefited from the delays. I'll phrase it that way.
That's a good way to phrase it. So what I'm taking away is, as a landlord, know your stuff or hire a pro so that you can be in a spot where you can have everything up to date. And you talked briefly.
As up to date as
possible, because no matter how up to date you are, there's going to be gray areas here. And then certainly vetting a prospective tenant as best as you can on the front end. We're starting to see, I've spoken with 2 clients in the last month who had properties up for rent, and tenants paid them a year in advance, wrote them a check for, hey, I'll take your rent, I'll increase it by $100, and I'll write you a check. So a guy was offering a condo in Oceanside for $2,900. Somebody wrote him a $36,000 check. Wow. I just want a place. How can we do that? And so as that happens, I think that what what we feel on the sales side versus the rental side is that the sales side has been crazy and the rental side is even more crazy.
Yeah.
Hundreds of applicants in a week's time. And I feel like, how do you differentiate yourself in these different types of things? And so before diving into the tenants and things that they can do, everybody always asks me as a realtor, like, who pays for what? As it deals with maintenance, hey, the dryer went out. And I have landlords that are saying, well, it's your responsibility. And I just try to like do that Homer Simpson fade into the
bush,
thing, like, I am not here. I am not here. No, I mean, that's not totally true. Typically, I put them in contact with you guys. But can you speak to that in terms of a breakdown of who pays for what? How does that get figured out? And is after a tenant has been in place for a year, does that change things significantly?
Well, there's a lot
There's so
involved
many
in what you
questions
just
there.
asked.
That was a very big question.
I mean, I'll
Objection compound.
I'll try to give a short answer, and then I know Nichole will probably, add on to that. But yeah, the California Association Realtor forms, those forms do have a lot of boxes in there that you can check for who's responsible for what. So it's, a good lease with the correct addendums that is a recent lease that's filled out correctly. And that going back to what we were talking about before regarding the exemptions to the Tenant Protection Act, there's actually a box that needs to be checked that I see landlords, they say, oh, I've got the good lease, right? And then I go, well, you didn't check that box when the tenant was signing it. And they go, what? So correctly filled out and put in writing what each party is responsible for. Now, there are specific laws regarding, utilities and things like that. Maybe Nichole can speak to more of that as I just recede into the Homer Simpson background here.
So in residential settings, there's a duty of habitability, and that encompasses several things, heaters, plumbing, that kind of stuff. Generally, a landlord is going to be responsible for those. And tenants can't waive habitability. You can't, say, I agree to not have working plumbing. And in the eviction setting, again, that's where our mind always goes. The law typically considers 30 days an okay time frame to get things done. Now, if a pipe is burst and there's water, take that with a grain of salt. But if there's a broken window, something like that, which windows, working locks, that kind of thing, are on the habitability list. So those are always going to be a landlord's responsibility. I have seen in addendums or whatever, people get down to the nitty gritty of even lawn care. Like, you're responsible for keeping my grass green or that kind of thing. So the parties can make their own deals outside of that, but you just can't in any way get a tenant to start waiving habitability. And then you can't, skirt that responsibility as a homeowner. And now responsibility, like, if the tenant breaks all the windows, I would still tell a landlord, don't let that just sit, but you might have another cause of action for the damage that they caused. And then you asked about the 12-month mark. And yes, if you are a non-exempt property, once you hit the 12-month mark, you are in the TPA. So
Gotcha.
You're starting to think about
What's the TPA?
Tenant Protection
okay.
Act. Yeah. So
My bad.
So you've got rent control at that
so
point.
you've got rent control and you've got eviction control, and you might have to be offering rental assistance if the reason for termination is a no-fault reason, meaning I, landlord, want the property back, not the tenant did something wrong and that's why I want the property back.
Which makes us think sometimes, property managers and property owners, will they start issuing 11-month leases? Right.
Yeah.
To make sure they're going to keep that property out of the Tenant Protection Act, rent control, all those things. 11-month lease right before the 12 months are up. You either get rid of that tenant or you negotiate something else.
But then it kind of looks at if you're exempt, then it doesn't matter. If you're a single family home, that's
why exemption is so important.
Right.
Maintaining it.
So we've only got a couple minutes left here. I kind of want to just talk briefly about strategies for tenants. And we alluded to kind of, again, talking the Southern California market about things that tenants are facing, which is crazy amounts of demand, crazy amounts of competition, and tenants that are starting to get creative in ways that they can get property. One of the things that I think is very important for our viewers to understand is that you guys represent both landlords and tenants. I'm sure, is that incorrect?
No, it's incorrect, Steve.
Only landlords.
Only landlords.
Yeah.
Okay.
So you're actually, you probably see more of what works for tenants than what we do.
Interesting.
In all honesty, yeah.
I mean, both of us in our current practice, we only represent landlords, but in our history, Nichole and I did both volunteer for volunteer organizations around town where we represented tenants.
Yes.
So, and in my practice prior to this firm, I represented some tenants. So we see both sides of it. But yeah, for what can a tenant do in this market? It's pay more money or pay a lot of money up front.
There's nothing legally that has you concerned about like a tenant paying that kind of money up front, like paying.
Yeah. So, I mean, there's always a lot to it, right? There's never, so if you're saying this deal is a month to month, but I'm giving you a year of rent, I mean, you might have an issue if you're trying to terminate on a 30-day notice or, it's kind of fact dependent.
Yes.
Right. And I will say we've seen that where a landlord accepts a year's worth of rent, says, this is great, cashes the check. 2 months in, landlord realizes the tenant is causing problems or is it the tenant's about to sue them for something, and you, guess what, landlord, you cash that check. They're in for a year.
Yeah.
So
it's very interesting. Well, we so appreciate you guys coming on the show. I feel like we could speak to you for hours, and it's not just
we'd enjoy that.
Yeah, not just because there's stuff to talk about, but because there's so many different scenarios, there are so many different circumstances, and certainly we'll put your contact information in so people can certainly reach out to you. Thank you guys for being here and for joining us
everyone.
yet again. Always an interesting takeaway. I hope that you took something away, and we look forward to seeing you again here on Contingent.
And we got to pay the bills, Steve. Can you guys follow us?
Oh yes,
yeah.
absolutely. Thank you.
We're on YouTube. You can watching us live on YouTube. Go to Apple Podcasts. Go to Spotify, Amazon Audible, pretty much anywhere where you get your podcast app. We got to keep the lights on. We need you guys to subscribe.
Keeping the lights on. See you sometime soon.